Okay, so I'll tell you about a Roman orator, a Roman counsel. His name was Cicero. What he said about cross-examination, that is very relevant. So he counseled and he said, and I'm quoting him, that in ancient Rome, one of the best, one of the finest lawyer, orator in ancient Rome said this about cross-examination. Nothing an advocate does is simple, but of all the things an advocate must do, by far the most difficult, the most complex, and the most subtle is cross-examination. Talent to cross-examine is a rare commodity. No more than 3 lawyers in Rome have it, and sometimes I wonder whether I am myself one of it. So this is what one of the greatest orator and the lawyer of Rome, ancient Rome, had to say about cross-examination, that this is something which is extremely rare. In similar vein, Mr. Ram Jethmalani also used to say the same thing about cross-examination. In one of his interviews, I remember, he said the art of cross-examination in India is dead. The problem is that a lot of lawyers do not have experience to the trial, and most of them perhaps start working with in the High Court or perhaps in the Appellate Court, Supreme Court. If they have never been to the lower courts, if they haven't done trial courts, trial advocacy, then it is extremely rare that they know and they have mastered the art of cross-examination. I would like to also tell you what is the purpose of a cross-examination. And in fact, before that, I would like to tell you that cross is the ultimate test of a lawyer's skill. You can judge a lawyer's quality by the way the person conducts a cross-examination. And why in arbitration it is very pertinent? Because arbitration at the end of the day depends on documents which have been filed by the parties. So in a way, it wouldn't be incorrect to say that you win a case on documents. And that's why there are certain arbitrations which are only document-based arbitrations. Sometimes there is not even a cross-examination. But that is, of course, by the consent of the parties. As you know that under the Indian Arbitration Act, Section 19 says that strict rules of evidence do not apply, and CPC also do not apply to arbitration proceedings, and only the principles behind the same apply. How cross-examination is conducted in arbitration is slightly different from how it is conducted before civil courts and the criminal courts. In an arbitration, the cross-examination is very flexible. It's much simpler, less technicalities. However, the objections may be the same in respect of cross-examination. I'll give you illustrations and examples. There are 2 reasons why we conduct cross-examination in any given case. Firstly, there may be certain evidence which is important for your case, and you want that evidence or that fact to come out before the tribunal. And that's why you cross-examine the witness of the other side to find that truth, to find out the veracity of the statements which have been given by the other side's witness. Like Anubhab rightly pointed, there are 2 kinds of witness. One is a fact witness who will give testimony on the facts of the case. And secondly, there are experts. Experts, however, may not be involved in every case. Essentially, in international arbitrations, we see experts coming because the cost is too high. So not everybody can afford experts. Now, what experts give testimony on? The experts give testimony on something like delay analysis. If there's an issue of delay involved in a matter, then you'll have a delay expert in the place. If there is an issue of quantum, you'll have a quantum expert involved in the place. Now, these experts are called independent expert. But interestingly, these experts are paid and involved by the parties, unless the expert has been appointed by the tribunal itself, which is rare. Now, the first thing that I told you is to bring out the facts which are relevant to your case and which will help you in your case. That is the first objective of conducting a cross-examination. The second reason for conducting a cross-examination is to demolish the case laid down by the other side. You confront witness with certain objectives and you say that your testimony is false. Whatever you have said in your affidavit, it is incorrect. and it is not in line with the factual position. So basically what two things you are doing? One is that you are bringing out the facts which are helping you. And the second thing is that you are demolishing the facts given by the other side, which are going to injure your case, which are going to be harmful for your case. So these two are the reasons why cross-examination is conducted. That's the long and short of it.
Correct.
Now there are two things. This is not just cross-examination. There is another thing called examination in chief. So what is examination in chief? Examination in chief is when your own lawyer asks you a question before the cross-examination, and then in that, the only interesting difference is that leading questions are not permissible in examination in chief, and in a cross-examination, you can ask leading questions. Now, what are leading questions? Leading questions are the questions which leads to an answer. For instance, if I ask my witness, what did you do on 10th March? Now, this is not a leading question because it doesn't have the answer. So this is the kind of question that I can ask in examination in chief. Whereas if I ask a question saying, is it correct that you were in Lajpat Nagar at 4:40 on 10th March? Now I am hinting towards an answer. This question itself is leading towards an answer. And that's why this is a leading question, which is not permissible in examination in chief and can only be asked in a cross-examination. Now, how do you master the art of cross-examination? What experts say is, you need to know the purpose of cross-examination, why it is relevant, and why you are cross-examining. Ideally, a lot of people think cross-examination is something which is mandatorily to be done. However, you need to first see whether it is necessary or not. You need to sensibly conduct it, and these are essentials for conducting any cross-examination. That you need to know what it is about, and you need to know whether it is necessary or not. So sensibly and carefully preparing for a cross-examination is of utmost importance, and knowing if it's necessary and accordingly preparing for it and strategizing how you want to go ahead, that is very essential for preparing for cross-examination. There are certain tips which I'd like to discuss with you. I mean, I'll tell you, like I have discussed already, the purpose of a cross-examination is to bring out the facts and see the veracity of the statements made by a witness. You confront witness with certain documents. You confront witness with previous statements made by the witness. And you try to bring out the truth in front of the tribunal, which is, of course, observing the whole cross-examination. The interesting thing is that during a cross-examination, the tribunal members are making up their mind. They are seeing the conduct of the witness. They are seeing the conduct of the lawyer. They are seeing your confidence level. They are seeing what answers are following, how important the witness is. All of that is being observed by the tribunal members. And believe me, that many times arbitrators and the tribunal members, they form their opinion during the cross-examination and they make up their mind. Even though award may follow subsequently, but that is the time when they get to know who is in a better position and whose side is, they decide the issues accordingly. So making up their mind during cross-examination, and thus it is extremely pertinent that you know what you are asking. Now, if you want to take certain notes, you can note down. I will briefly tell you the pointers because I think that might be relevant. The most important question is whether you want to cross-examine the witness or not. This is the first tip that I want to give you. There may be 3 witnesses from the other side. Supposing I am the claimant and the other side is the respondent. I have given 2 names as my fact witness in the list of witnesses, and the other side, the respondent, gives 4 names. All those 4 witnesses of the respondent whom I have to cross-examine may be giving testimony on different aspects of the case. Now you need to identify which witness is crucial and which is not. Because in every case, if you see the issues which are involved, they're very narrow. Not every relevant or not every witness may be giving testimony on the relevant issues involved in the case. And tribunal at the end of the day is only concerned with the relevant issues which have been identified in the case to arrive at a conclusion. So if you first thing that you need to do is that you need to consider whether you have to cross-examine a particular witness or not. Because if you cross-examine a wrong witness who is otherwise not very relevant, then you might end up injuring your case, harming your own case. So if it is not relevant, do not cross-examine. Now, by saying do not cross-examine, I'm not saying that say I don't want to cross-examine. You may keep it very brief, you may keep it very short, but do not cross-examine that witness at length who might end up injuring your own case. Now, the second thing which I'd like to tell you is that control your demeanor. Why it is absolutely necessary? A lot of times, if you've seen in Bollywood movies and Hollywood movies, they've shown it's like compelling the witness to speak something, getting angry, screaming at the witness getting emotional, giving confessions, etc. And to my mind, I haven't seen these things happening in real life, in practical world. And these are very, very rare, maybe. Your demeanor plays a very important role because when you are cross-examining as a lawyer, the arbitrators are looking at you. How sensible you act, how pleasant you act, how confident you are. That is extremely relevant. Because if you act frustrated, the arbitrator might get an indication that because he's not getting those answers and because his case is weak, perhaps, that's why he's losing his mind, he's getting angry, he's getting frustrated. So many things depend on that. So your demeanor plays a very, very important role. Sometimes what happens is I've seen lawyers, when the witness of the other side doesn't give a good answer, the lawyers act surprised. And that is when the arbitrator gets the idea that the lawyer is getting surprised, perhaps something is fishy, etc., etc. So you have to control your emotions. You have to be very calm and composed while conducting cross-examination. The idea is not to threaten the witness, make him comfortable, and then get the favorable answers. It gets easier.
Yes.
Keep it simple. That's the third advice that I want to give you. Keep it short, crisp, and brief. Do not ask long explanatory questions, saying 100 things in that. Just ask simple questions. Keep it short. Do not make it do not make it something which is very long and explanatory in itself, which confuses the witness, because then arbitrator gets a feeling that the lawyer is trying to confuse the witness, which is not a good sign.
Okay. Just to
Cross should be short, and you need to stick to the real issue involved in the case. Why you need to stick to the real issue? Do not do a fishing on roving exercise. Do not ask irrelevant questions because the time is limited. And the idea is to bring out the facts which are relevant to the controversy to determine the real issues involved in the case. Therefore, the questions which you are asking must revolve around the controversy which is involved in the case and which will help the arbitrator in arriving at a conclusion. Therefore, it is extremely necessary that you don't ask irrelevant questions and stick to the main issue which is involved in the case. One important factor is that ask only those questions which you feel are going to help you in your case. The important thing is that you yourself must know what the answer is going to be. If you do not know what the answer is going to be, do not ask that question at all. It might end up ruining your case. So the idea is to ask only those questions which you are confident will be favorable to you, and you already know what is going to be the answers to those questions. And why do I say so? So the next tip which I am giving you is that avoid open-ended questions. This is the most important advice that I'm giving you. Never, ever, ever ask open-ended questions. Now, what are open-ended questions? Open-ended questions are that I'm asking you, okay, please tell me, why did you do this? then the person can give all the reasoning in the world and can justify his acts, etc., and clarify the case, and therefore damaging your whole case. So do not give any witness that opportunity to explain and clarify his answers. Because if you ask open-ended questions, you are giving a long latitude, too much of latitude to a witness to speak. And he can say anything, and that will be eventually read in evidence and used against you. So do not give him that opportunity, especially when the witness is an expert witness. I'll give you an example. Assuming that in a case, the issue involved is of delay, which is a very common issue in construction contracts. If there is a delay expert in place, and if you give him an opportunity to ask or explain about the delay and how do you think that delay in this case was attributable to us and not them, he will be able to tell you everything relating to delay, which will eventually damage your case. So don't give him that opportunity to use his expertise against you. Therefore, ask only closed questions. Now, what are closed questions? A closed question would be asking him simply, is it correct that you terminated the contract on so-and-so date? It's a closed question, very short. Instead of asking him, please tell us why did you terminate the contract? Because then he can justify, he can explain. Your endeavor should be asking yes or no questions. And you already know that the contract was terminated, then you say yes. He will obviously say yes because he has terminated the contract. I'll give you an illustration. Assuming that in the contract, there was a clause that termination can only be done by sending a prior notice. And assuming that a prior notice was not sent in this case by email, which was mandatory as per the clause. So instead of asking him a question, why did you not send him by email? He can explain anything. He will give you the justification. I didn't send because I served him by registered post, etc., etc. And he gave an acknowledgement. Instead of asking all this, simply ask him, is it correct that as per the contract, the termination was sent, a notice was to be sent by email, and you did not do so? He has to say yes. And that's how you just stop there. You've got a favorable answer.
Right.
The next step is you should know when to quit. This is extremely important. Some people, what they do, when they get favorable answers, they keep on going. They like to ask many questions. They think that it's going to add up and clients are going to be very happy. But the idea is the moment you get the favorable answers and you think you have already taken out the best from the witness, you stop then and there. And you say, I'm done with this witness and I'll be cross-examining the next witness. Because if you ask follow-up questions, which many lawyers do, then you are giving an opportunity to the witness to clarify his case and to clarify the previous answers which were in your favor. And eventually, that will also not be helpful. So the moment you get favorable answers from a witness, you stop then and there, and you do not cross-examine him any further. The idea is not to ask many questions, but the idea is to get favorable answers and then just stop. Sometimes you see that there is a witness who is extremely good. Sometimes the witnesses are very smart. So be very careful with those witnesses. Do not give them an opportunity to testify and explain their case. Because the idea of a cross-examination is to confront a witness. When he's saying something in his affidavit, you have the opportunity to show that this is not true. You have the opportunity to tell the tribunal that his testimony cannot be trusted. We cannot trust this person. And what kind of questions you can ask in this regard. You can ask about his past conduct. If you have to prove that what he's saying is wrong, you can do following things. Firstly, you can confront him with a document. For instance, if an expert is saying that in the past 5 years, the steel industry was suffering heavy losses. So maybe you can show him a report and say, no, what you say is incorrect in para so-and-so in view of this document. You confront him with a document. So that's one way of showing that the witness is not credible and we cannot rely on his testimony. The other thing that you can do to show or shake the confidence of a witness is by asking him that in your previous statements, you had said this, and now you are saying this. So contradicting him
Precisely.
in his own answers or perhaps in his own testimony. So that's the other way of shaking his confidence and shaking his credibility and telling the tribunal that he cannot be relied upon. The other interesting thing which I'll tell you is that you should always ask leading questions. I've explained you what leading questions are. So whenever you are cross-examining a witness, you ask him questions like this. I will give you a sample. Is it correct that you did not send a termination notice prior to the termination? Now, you are asking, is it correct? You are hinting towards an answer. So he has no choice but to say yes.
Yes or no.
And then you build your whole case like that. The tribunal is seeing what you are hinting at and what your case is. So you are building your case by virtue of asking such questions.
Correct.
Is it correct that the claimant faced heavy losses due to your termination? Is it correct? Is it true? I suggest to you, I put to you. So put your case to the witness and why it is relevant. In many cases, what has happened is, if you don't put your case to the witness, then in a way, you are admitting what he has said in his affidavit. Supreme Court has, in fact, in various judgments, said that because you had an opportunity to cross-examine the witness and you did not cross-examine him on the vital aspects of his testimony, therefore now you cannot say that his testimony cannot be relied upon. He has proved his case by virtue of the affidavit which he has given. You had an opportunity to cross-examine him on that, to confront him on that, and to show that his testimony cannot be relied upon and the veracity can be questioned. So this is the long and short of the cross-examination, which I thought I will discuss with you. And I think I have taken too much time already. But in case you have any questions, briefly, we can have some question answers. Now you can unmute everybody. And if there are questions, I think there may be many questions.
So add to what Tariq said.
I'm glad there are no questions so far. The host can unmute participants and if unmute all. Just one second.
Right with that, but I if anyone wants to speak though, they can unmute themselves and they can. If you have any questions as well.
Just to add to what Tariq has said, what Tariq has said is absolutely relevant.
I can't hear Anubhab. 1 second. Can you unmute Anubhab?
He is unmuted.
Can you hear me now?
Hi. If everyone could just confirm, can we hear both the resource persons, Tariq sir as well
just
as
1 second. I need to see.
Am I audible,
Okay.
guys?
Yes.
Am I audible?
Just 1 second, guys. I think there's something wrong with my audio.
Okay. In addition to
just 1 second, guys. I don't know. I think I cannot hear what you guys are saying. Just 1 second. Okay. Anubhab, can you hear me now?
I can hear you. Can you hear me?
Yeah, I think, but you're not very loud, but that's okay. So if anybody has questions, please send me on text. You can comment and I can read it there.
Yeah. And just before that, in addition to what Tariq has mentioned, okay,
Yeah.
all of these are credible points. The most important being that you should know when to end. Other than that, something which I have followed whenever I've had the opportunity to cross-examine or something of that sort is to bifurcate your questions as per themes. Okay, theme of the dispute. Okay, so you know that when you're cross-examining a witness, so your question should be as per topics. Okay, and it often helps to juggle from one topic to another and come back to that topic again to confuse the witness. Okay, it's imperative, like Tariq said, that you confuse the witness to such an extent that he contradicts himself. Okay. Now, why do we do that? We do that so So the whole switching between themes and bringing him back to a certain theme question is to basically confuse him at a certain level, so that he contradicts his answer which was given by him before. Secondly, what Tariq said is you should know when to end. It is particularly important because once you get a response in your favor, you think that your subsequent responses will also go in your favor. It is not. And once, if you have had the opportunity to prove that the witness testimony is defunct and that is substantial for the case at hand, it is ideal that you stick to it. Tariq, before we take questions, if we can show just an extract of a cross-examination.
Yes, please.
Yeah.
I hope I was audible throughout. I am not sure.
Yeah, you were audible. You were audible.
Okay,
that's why I got to know.
Yeah, if anybody has any questions, please let me know.
Yeah.
Good that nobody has any question for me.
Yeah.
Oh, there is, I think. What is that question? Let me just see if it's for me or if it's for anyone.
It's basically, how do you conduct cross-examination in a world where you're going to have virtual hearings? And if I may, how do you tackle witness coaching and other practical inefficiencies? And I think if I may take this a little further, there is an art to cross-examination. There's psychology involved. Do you think bringing in technology over here will disconnect us from connecting with the psychology of the witness that we're cross-examining? How do you conduct cross-examination in the age of technology, though? That's I suppose, the question.
I think this is going to be the future, because I think that the future of justice is online, and now we are only going to have, I think it will be encouraged quite a lot. Like you're seeing daily nowadays, Supreme Court and High Court, they are functioning online. I don't think it makes any difference, frankly, because at the end of the day, the only advantage that a tribunal has is that they can see the conduct of the witness. They can see how he's acting when a question is being asked. I'll give you an illustration. For instance, there is one technology in international arbitration which is extremely successful. That is transcription services. So before you even finish the question, the way I am speaking right now, it's all on the screen. There is no traditional typing methodology. So technology is making it extremely convenient and extremely fast, because the cross which used to take like 5 days or 6 days is being conducted in a few hours. Similarly, it's very, very convenient, and I think it's an add-on, because witnesses unnecessarily used to fly from Sweden, from France, from Italy, and now at the comfort of their office, perhaps they can be present in a video conferencing, and everybody sitting at the comfort of home can join in a common meeting. And like the way we are conducting Zoom class today, I don't see any difference. And it is extremely convenient. It's and the same way the arbitrator can give oath to the witness, and the witness can say the oath that I will speak the truth, nothing but the truth. All the documents can be present in front of him. The arbitrator is watching, the other side is watching. Nobody can prompt the witness. So I think it's going to be extremely convenient. Unless we start doing it, it may appear to be very different, but it will be very smooth, I think.
Technology, like Tariq said, has helped cross. So you will see that domestic arbitrations, at least till 2-3 years back, also they used to have we used to have typewriters, people typing things out while you're asking the question. So basically, it needs to be accurately transcribed. So your questions are slow. It gives adequate time to the witness to think their response, fix their mentality, and all of that. But nowadays, every lawyer who's cross-examining has a monitor in front of him. So, for example, when Mohit shared that screen and you see that I'm asking a question, taking him back to another question, is primarily because I have a screen in front of me, and I can take him back saying that line this at 2:45 p.m. you have said this. and the witness also has a monitor in front of him. So both of them can check, and it has definitely helped us immensely. Normally, these procedures, like Tariq rightly pointed out, takes 5 to 6 days, and now we get it done within, like each witness gets done within half a day, if not longer, like not even half a day, lesser than that, and it's concise and precise. And it's the call of the time to make sure that we anyway, international arbitration, commercial arbitration can get to be expensive affairs at times. So if you can cut down on a bit of its costs, why not, when there is an opportunity to do the same?
If I may just pop in, and this is probably a suggestion for all who are interested as to how technology is being used in arbitration. There was a very recent webinar conducted by the Korean Commercial Arbitration Board, wherein they basically looked at how Zoom and other technologies could be used for examination. And insofar as tackling witness coaching is concerned, because of course, when you have when you only have a webcam in front of the laptop, there could be other individuals sitting next to the witness and no one would realize. So there's technology which is being adopted. One solution to that has been that in the room where witnesses are sitting, you could have 2 or 3 cameras looking at the witness from various positions, so as to see that they're alone and not with someone. So the technology, I suppose, will be forced to develop. Necessity is the invention of all good technology, I suppose, as to paraphrase. So I suppose that as we go ahead, we'll be going ahead with more improvements in technology. We have a few other questions. We have one from Fez. I think everyone can see that. So Tariq sir, if you would want to take that up.
There's one from Karan Suneja, if I'm not wrong. I read it. What he's asking is that, assuming that the parties consented that there'll be no witness affidavit, and when the award is, the arguments are going to start, before that a party says, no, I want to lead evidence. Can a review of such a consent order be maintainable or not? We did this in one of our arbitration, that we didn't give one affidavit of a witness. And before the final arguments, when the evidence stage was over, we moved an application for taking on record that affidavit. Ordinarily, it is not permissible. It is not allowed. To my mind, no arbitration tribunal will encourage this practice because it is not in line with the scheme of the act, which is finishing a matter within a year's time, now 6 plus 12 months. But since arbitration is flexible, and if there are circumstances which have emerged, or if some new discovery has happened, then subject to provisions of cost. In that case, I'll tell you the application was allowed, but the cost of 40 lakhs was imposed on us. Subject to payment of cost, this was being allowed because it caused a lot of inconvenience to the parties as well as to the tribunal. Because then, if there is an affidavit, then the other side may also get an opportunity to file an affidavit. You may also want to read a judgment of Justice Nariman. There's a judgment Canara Nidhi, in which additional evidence was allowed even at the stage of 34. So all of that will help you. Yeah. So in the interest of justice, anything can be done. Arbitrations are flexible, but rarest of rare cases. What is the next question?
I think it's a generic question. Tariq, do you want to take it? It's about how do you think the recession is going to affect the legal job market? Tariq, go for it.
I think there was an article day before yesterday that lawyers are facing a lot of difficulties. I don't know, Anubhab, if you read it or not, but it was saying that people in the legal profession are facing a tough time. Essentially, those independent practitioners who depend on this and who have to pay salaries, the ones who are, who were depending on the court matters because they were filing regularly, and now there has been no fresh filing, only urgent matters are being listed. So I think litigating lawyers are facing a tough time. They have to maintain an office, they have to pay the salaries, and there are no fresh filings. They depend on that. And that's why perhaps the Bar Council of India as well as the Delhi High Court Bar Association have taken initiatives to support these families, to support these lawyers.
And all of that. Yeah.
Yeah, absolutely.
Yeah. Guys, these are difficult times. Let's just be very honest. These are difficult times. But the thing is that what is the only thing which you can draw from this period is that it's not that you or me or X and Y, Z are in this situation together. It's everybody who's in this situation together. Coming back to the particular question, of course, it will affect the job market. In ways we still don't know. Um, uh, I don't want to paint a rosy picture because it's still locked down, but we hope that it does not. We hope that everything comes to returns to normalcy as soon as the lockdown ends. We hope that our arbitration disputes, Akash's commercial transactions, Tariq's arbitration matters, everything returns to normal as soon as this lockdown ends. And we can only pray for it, because for me, for example, a law firm which is only 2 years old, these are tough times, okay, because you depend on revenue stream which is day to day, or month to month, or quarter to quarter. Um, um, but we all sail in the same situation. This is the time you need to be close to your clients as much as possible. You need to make them aware that you're present. You need to send them updates. You need to make sure that you are in touch with them. This is the time you increase your business development activity. You write articles, you do classes, you keep your visibility up there. And in terms of the job market, what I read an article by Law 360 the other day. It envisages a meltdown for 6 to 9 months uh, after the lockdown ends. But I think with the end of the lockdown, there will be a addition of a lot of other sorts of dispute also. Okay. So that might be a different thing. But presently, we are all in the same situation together. Everybody's in the same situation together. My friends who are in big law firms, like when I say big law firms, like top six, uh, they've they have some sense of security. But leaving the top six, what I have seen through my experience is that things might get a bit unscrupulous at times.
So interestingly, even those firms are reducing in size, and so a lot of people might get notices, and they are trying to reduce the number of the employees. I mean, that's what I've been told.
Yeah, same. Though a certain firm which consists of two brothers have given a 5% hike in their bonuses. That's what Bar and Bench tells us. But things are difficult. But hopefully we'll be through this. Yeah, like we will all be through this.
In nutshell, fancy lawyers like Anubhab will have no issue, but people struggling lawyers like us, like me, and perhaps some of you, will have a tough time. So we'll just hope that things get back to normalcy. And
I will get back to you on that sometime soon. But yeah.
The thing is, another question by, I think, one of your Anubhav, would you like to take that question?
Yeah, let me see. So I think. So do you think fields such as insolvency, bankruptcy, debt restructuring will increase in practice? There has been a notification by the Ministry of Corporate Affairs dated 24th March, if I'm not wrong, 0125. 0125 notification number after the Finance Ministry directive. What it has done is that it has increased the claim, the dispute amount from 1 lakh to 1 crore. So you will see a lot of those cases also decreasing. So the IBC industry, and this is for the next 6 months. So it's from March 24th, so count the next 6 months. I'm sorry, I've just been the harbinger of bad news so far.
There's one question by Ankit. Would you like to take it?
Where's I can't see Ankit's question.
Ankit Tripathi.
Has amended its rules and regulations, including hot tubbing of witnesses through its. Please go ahead. You are the Delhi High Court person.
Okay. So the thing is, Ankit, the hot tubbing method was not being used initially in India, at least, but it is one of the better methodology for cross-examination of experts, where both the experts are made to sit together and questions are asked by the tribunal. to arrive at a conclusion and to find out the veracity. Because when both of the witnesses from both sides are present, then it is easier to find out what is the actual expert position on a particular issue where tribunal is not up to date, and tribunal can take the help of these. I think it assists the tribunal in a better manner. And yes, I hope that in future we adopt this practice. However, so far I have seen that in arbitrations, it is not very popular in India, even in international arbitration. Okay, then there is another question on hot tubbing, but we have to see how it turns out in India. Just one second. Hot tubbing is just a remove a possibility of bias. Why would that change whether it is in court proceeding or arbitration? I mean, see, it completely depends how, so far as arbitration is concerned, it is on the parties and their lawyers to decide whether they want to go for hot tubbing or not. Traditional method is always preferred because counsels as well as people are accustomed to that. But like I said, I personally prefer a hot tubbing of expert witnesses, because I think that reduces bias, and actually the meaning of the word independent experts gets some meaning with hot tubbing. So yeah, I think I agree with the person Sonali. Yes. Sonali, parties decide the course of action, and the tribunal, of course, sends an email and asks whether parties want to go through, unless the tribunal insists. And tribunal, because the idea is that tribunal always takes the suggestions of parties whenever there is any procedural methodology which is to be adopted, and the comfort of the witnesses, comfort of the parties is obviously paramount. But at the end of the day, the tribunal decides all of that, and this all happens when the schedule is being charted out. There was one more question: is there any specific time limit to cross-examine any witness? There is no time limit as such, but the tribunal fixes it. Tribunal in international arbitrations, the practice that we have seen is the tribunal will say, okay, we'll give you 2 sessions for cross-examination of claimant's witness and 3 sessions for cross-examination of respondent's witness, depending on the number of witnesses that are to be cross-examined. As such, there is no time limit like 4 hours, 5 hours. The scope of cross-examination is very wide.
And normally the international arbitration tribunals, what they do is that they normally ask each of the parties saying that how much time do you think you will need, how much time do you will need. And based on that, they come to a consensus, and they do a plus minus 30 minutes of that, and they come into. So let's say I start today morning at 10 a.m. He said that the tribunal will be like, so would you be able to finish by lunch? So that means my time stipulation is till lunch, and then there'll be re-examination maybe after lunch, and then we move into the next witness and so on and so forth. So that is a basic understanding. There's no time stipulation. And like Tariq pointed out earlier, with the transcribing services that we have, these transcribing services at times charge more than the lawyers per day, and they are mostly from abroad. They come from abroad, and they are exceptionally fast and well. Like you get real time data, and at the end of the day, you get the whole transcript, and
accurate.
Yeah.
Any last questions? Because I have to leave for another webinar. One or two questions, anybody?
Yeah, we can take 1 or 2 questions.
I think
we can probably. I don't see any more questions coming in. Just this one general question, and I'll bring this back again to cross-examinations and juxtapose it with examination. Actually, a perception that many have, which I've sort of come to adopt, is that when you're examining someone, the attempt should be to get a detailed descriptive and narrative answer out of them. Whereas when you're cross-examining someone, the answers that you need you should ask questions such that they don't get a lot of opportunity to ramble. They give very specific answers. Is that a possibility? How do you think then should we focus on structuring our questions that we ask for cross-examination? Any guidelines for that?
If I just tell you a form difference. Examination is rehearsed, a cross-examination is not rehearsed. Okay. Examination is more often than not rehearsed. Okay. So I will of course ask questions which are explanatory, dilatory in nature. Okay, and okay, guys. One more thing I've forgotten to tell you guys. I think I don't know if Tariq,
Patwa. Alayya patwa.
I don't know if Tariq will agree to it. There are times you might get instructions from your client to prolong a witness so long that the next witness does not come on the same day. I don't know if it has happened. It has happened to me. Like so,
Yeah, it has happened. It's common.
it
Sometimes clients also say that you have to ask him too many questions and trouble him quite a lot. I don't like him.
yeah, I don't like it either because when you ask too many questions, that's when you get hit by objections left, right, center from the opposite side, and then you can get moved out of your soft zone because you are in the middle of tackling the opposite lawyer, tackling the tribunal, and tackling the witness. You are out of your zone.
Yeah.
Recently, I think last month, we were in an arbitration, Akash and I, and opposite us, there was a very prominent senior advocate who was opposing us. And of course, we were already intimidated. And then, with the instructions of the client, asking irrelevant questions, prolonging the session, uh, hearing from the tribunal, stopping the senior advocate, getting answers out of making sure that I don't ask repetitive questions. Very, 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 very difficult. So try and avoid that to the greatest extent. That's why we say that make it short. But there will be times when clients will come up to you and tell you that no, I want to continue this witness for today. These are strategies, simple strategies, and I want to make sure that the next witness comes in the next tranche because there'll be some development before that. These are just strategies. So you have to be very, very attentive then. Because with the number of irrelevant questions you ask, the number of objections increase. And with the number of objections increase, the number of interferences by the tribunal increases. And then your concentration just goes for a toss. Okay.
Okay, and I think we have no further questions. So I'll end by saying that there's a famous saying that the best questions in a cross-examination are the questions never asked. So that's the long and short of it. Okay, everyone, thank you very much for this, for a patient hearing and for this excellent interactive session. If you have any questions, I think my LinkedIn has been shared. If you feel free to ask for it. Thank you, Ardhendu, Shekhar. Thank you, everyone. It's been a pleasure to have you all